This presentation was originally created in October 2020 for members of NCMS, a society of industrial security professionals involved in protecting classified national security information. Throughout the presentation, FSOs are repeatedly mentioned. FSO stands for Facility Security Officer, the person responsible for security at a cleared DoD contractor facility. The purpose of the presentation was to give FSOs some insight about SORs and how to help the people they sponsor for a national security clearance respond to an SOR. An SOR, or Statement of Reasons, is a document attached to a letter from the DoD Consolidated Adjudications Facility, explaining why the government does not intend to grant an applicant a security clearance. I'm William Henderson. The voices you will hear in this presentation belong to Robert Welch and to me. Bob and I are co-founders of the Federal Clearance Assistance Service, known as FedCAS. We started FedCAS in 2012 to help people with federal clearance eligibility problems. We are not attorneys, but we help people at all stages of the clearance process, including representation at clearance hearings before administrative judges at the Defense Office of Hearings and Appeals, known as DOHA. Bob previously served as an Army counterintelligence agent, focusing on personnel security investigations, and later as a human case officer assigned to a special office supporting the Assistant Chief of Staff for Intelligence. After leaving the military, he worked in the high-tech materials and pharmaceutical industries. Since its founding in 2012, Bob has conducted many consultations for FedCAS clients and has made numerous presentations at security conferences and to corporations regarding personnel security investigations and adjudication guidelines. He holds an MBA from the University of Maryland. I've been a personnel security consultant since 2007. Prior to that, I was an investigator and supervisory investigator for the Defense Security Service and for the Office of Personnel Management. I've also been a security manager for Ford Aerospace and an Army counterintelligence agent. I've written 2 books and numerous articles on federal personnel security programs. My books have been used as textbooks at several universities and colleges. I've been interviewed on national radio programs and quoted in national newspapers on federal security clearance issues. I've also been retained as an expert witness on cases involving security clearances. A few months ago, I got a phone call from a guy, we'll call him Charlie. Charlie's facility security officer recommended he contact us for help in appealing his security clearance denial. Since a lot of people get the terminology wrong, I assumed Charlie received a letter of intent to deny clearance along with a statement of reasons. I asked him what agency had sent him the notice, and he said DOHA. Contractor SORs are issued by the DoD Consolidated Adjudications Facility, not the Defense Office of Hearings and Appeals. But I knew that this was about to change, and perhaps he was one of the first to be issued an SOR directly from DOHA. Charlie then tells me that the government attorney said the documents he submitted were fine, and based on the judge's suggestion, he later submitted some letters of recommendation. Well, obviously, Charlie was well past the SOR stage. He had already had a hearing before a DOHA administrative judge, and the judge had denied his clearance. After questioning Charlie a little bit more, I learned that he received an SOR citing financial considerations. He answered the SOR by himself and requested a hearing. He took documents to the hearing that showed he was paying off his delinquent debts. The DOHA Department Counsel and the judge questioned him about the debts. The judge even suggested that Charlie obtain some letters of recommendation, and the judge offered to keep the hearing record open for a couple of weeks so Charlie could submit the letters to Doha. This was more than the judge was required to do, but ultimately it made no difference to the outcome of the case. Charlie wanted my help in appealing the judge's decision. He asked me what I thought and how much it would cost. I told him that statistically less than 3% of applicant appeals at Doha are successful, and that the appeal would probably cost about $2,000. I suggested he send me a copy of the hearing transcript and the judge's written decision so I could give him my opinion of his probability of success and exactly how much it would cost. Well, I never heard from him again. So what went wrong with Charlie's case? Well, first off, he thought he could successfully answer the SOR by himself. I don't know at what point his FSO advised him to get help, but by the time Charlie contacted me, it was too late. Applicants need to know that getting an SOR is a serious matter. Less than 2% of contractor clearance investigations result in an SOR. Here's what typically happens with SORs. 23% of applicants don't bother to respond to the SOR, and their clearances are denied with no further action. Only about 18% of SORs are withdrawn by Doha based solely on the written response to the SOR. About 20% are granted a clearance by a Doha judge, and about 39% are denied clearance by a Doha judge. Overall, about 62% of the people who receive an SOR are denied clearance. Once a judge denies or revokes your clearance and you get to the appeal stage of a Doha case, it's almost impossible for an applicant to win. Sheldon Cohen, an attorney who's now retired, did a multi-year study of Doha appeals and found that less than 1% of applicant appeals were successful. My own analysis of a much smaller sample of cases found a 3% success rate. It's important to understand that a Doha appeal is a written argument asking a 3-member Doha appeal board to overturn a Doha judge's decision. An appeal is not the written response to an SOR, nor is it the presentation of your case to a Doha judge for a decision based on a hearing or based on the written record. Doha appeals are very narrow in scope, and no new evidence is permitted. Many applicants are denied a clearance because they don't know what information needs to be presented to mitigate the security concerns listed in an SOR. Here's a portion of a typical SOR for financial considerations. You'll notice that the overall security concern is cited in addition to specific delinquent debts. Like many applicants, Charlie answered the allegations regarding the specific delinquent debts on his SOR. He admitted or denied each of the allegations in the lettered subparagraphs and explained that he had either paid off the debts or was making installment payments to the creditors. He also attached evidence of the payments he made, but that's all he did. He didn't address the overall security concern listed in paragraph 1, guideline F, and he failed to include any other potentially mitigating factors in his case or present any information that would result in a positive whole person assessment. The National Security Adjudicative Guidelines provides examples of mitigating conditions specific to each of the 13 guidelines. Paragraphs 2D and 2F of the adjudicative guidelines provide additional potentially mitigating factors applicable to all 13 of the guidelines. Like others with delinquent debts, Charlie thought all he had to do was show that he had either paid off or was paying off the debts listed on his SOR. There's always more to it than just answering the specific allegations on the SOR. For cases involving delinquent debts, in addition to the item number 1 on the slide, DOHA judges also want evidence that prior to his financial problems, the applicant paid his debts as agreed. The financial problems were caused by circumstances largely beyond the applicant's control. The applicant acted reasonably and responsibly under the circumstances. The applicant has received or is receiving financial counseling, preferably from a nonprofit agency affiliated with an organization like the National Foundation for Credit Counseling. The applicant has the current ability and intent to pay his debts, and there's little likelihood that the problem will recur. Which of these points is not mentioned in the adjudicative guidelines, but is critical to mitigating a financial concern? It's item number 6. What's needed here is a clear statement by the applicant of his intent to pay, along with evidence of income, such as a current pay stub. He'll also need a personal financial statement that shows monthly income, expenses, and debt payments. Unfortunately, Charlie went to the hearing alone with only some documents showing that he had paid or was paying his debts. He wasn't prepared to discuss the underlying reasons for why his debts became delinquent, and he didn't bring any documents with him to support a positive whole person assessment. On average, 4 out of 5 applicants choose to represent themselves at a hearing, and only about 32% of them are successful. By comparison, applicants represented by an attorney or personal representative are successful about 51% of the time. This is because, among other things, good advocates know that it's essential to tell a story about the specific allegations, but also a broader story about the applicant's background, how the overall problems evolved, how he coped with the problems, how he resolved the problems, and why it won't happen again. The story needs to be written in first person and written in a way that invokes empathy. Charlie's company made a significant investment of time and money in recruiting, hiring, and onboarding him. All of that was lost, and HR had to go through the process all over again of finding someone to fill the position Charlie had been hired for. And as for Charlie, he probably left a good job to accept the job that required the clearance. And now, with a clearance denial on his record, he'll probably never be offered another job that requires a clearance. Once, after a presentation we made to an NCMS chapter, an FSO asked us, "What can you do that I can't do myself?" Well, nothing, if you've done dozens of successful SOR responses, and you know how to present an applicant's case to a DOHA judge. But I understand that many FSOs are limited in the help they can give their company employees, either because of their company's policy or because they don't have the time or experience to do it. It takes us 10 to 20 hours to write an SOR response. You probably don't have that much time to help one employee. And what if you did, and he was denied a clearance anyway? Would you be held responsible for the failure? To what extent would you or your company be liable? You've all seen the double envelope from DoD-CAF. You never know whether it contains an interrogatory or an SOR unless the applicant tells you. But it doesn't matter, because in most cases the interrogatory is just as bad as the SOR, and it's often a precursor to an SOR. The purpose of the interrogatory isn't necessarily to give the applicant a chance to explain what happened. It can simply be to get him to certify the accuracy of the subject interview portion of the report of investigation, so it can be used as evidence against him. Most people don't realize that in a Doha case, the only portions of a report of investigation offered as evidence to the judge are the subject interview and the attachments to the report, such as police records and credit bureau reports. Without an authenticating witness, the subject interview portion of the report can easily be excluded as evidence simply by objecting to it. However, if the applicant has already certified the accuracy of the subject interview portion of the report, it's not possible to exclude it as evidence.
Here's what the Doha Department Counsel typically submits as evidence against an applicant in a case involving financial consideration. 1. The SOR and applicant's SOR response. 2. The EQIP-SF86. 3. The summary of enhanced subject interview. 4. Credit bureau reports. 5. Other relevant financial documents such as bankruptcy, repossession tax liens, judgments, or loan records. The first 4 items on the list are common to most cases. For cases involving criminal conduct, there will usually be police or court records. For foreign influence cases, there will be a request for administrative notice concerning the relevant foreign country. So what happened to the other portions of the report of investigation, especially the part where applicants' friends, neighbors, and work associates said such good things about him? The Doha judge never sees them because those portions can't be submitted as evidence without authenticating witnesses. Doha doesn't have subpoena power, and they won't pay to have anyone testify at a hearing. What about the whole person concept? Well, if an applicant wants whole person factors taken into consideration, he'll have to submit them to Doha himself by getting people to write letters of recommendation or testify at the hearing on his behalf. Applicants should also submit copies of work and academic performance records, awards, special recognition, and other positive achievements, including constructive community activities like volunteer and charitable work. So, what should you, as the FSO, tell an employee when they receive an SOR? We recommend, number 1, make it clear to him that if he doesn't make a timely response to the SOR, his clearance will be denied or revoked. Second, impress upon him that without an extension of time, he has only 20 days to submit a response to the SOR. 3. Advise him to immediately request a copy of his background investigation from NBIB using Form INV 100. He can ask for expedited service, citing his need to respond to an SOR and by including the ISCR case number. Ask that the file be sent to him via secure mail. The INV 100 is available at the DCSA website. Number 4, recommend that he study the applicable sections of the National Security Adjudicative Guidelines that are attached to the SOR, including the general criteria at paragraph 2D, and if appropriate, the additional factors for people who already have a clearance at paragraph 2F. 5. Tell him about the low probability of success, especially if he tries to do it without help. If he chooses to go it alone, you should tell him to Number 1, request an extension to the due date for the SOR response. 20 days is never enough time to prepare a good response to an SOR. It's almost never possible to get a copy of the investigative report within 20 days. Executive Order 12968 states that if it's requested, the investigative file must be provided prior to the time set for a written SOR response. On the letter that accompanies the SOR, there is an email address for submitting questions regarding procedures for answering the SOR. A request for an extension can be submitted to that email address, but remember to cite the ISCR case number. 2. Go to the Doha website and read case decisions on cases similar to his to get an idea of what it takes to convince a judge that the issues have been or are being resolved and are unlikely to recur. On the last slide of this deck, we've provided links to the important website and reference materials. Number 3, get and attach documents that show the security issue has been resolved, such as financial, police, and court records. If it's a financial issue, include a personal financial statement and a current pay stub to show his ability to pay debts. 4. Get and attach at least 6 letters of recommendation from work associates, friends, and neighbors that talk about the security issue, if possible, but at least covers all the positive aspects of the applicant's character and conduct, including honesty and trustworthiness. If it's a foreign influence case, the letters need to address national loyalty, allegiance, and attachment. The letter should end with a recommendation for security clearance. This is not a reference letter for grad school or for employment. The judge does not care about the applicant's technical skills or knowledge. The judge wants to know about character, conduct, and willingness to comply with rules, as well as information directly related to the security issue. Number 5. As previously mentioned, he should get and attach other documents that will support a positive whole person assessment. Number 6. He needs to do more than just answer the allegations on the SOR. As I said before, the applicant needs to tell a story about himself, a story in first person, written in a way that elicits an empathetic response from the reader. The story should be added to the sworn affidavit and after the applicant's answers to the individual allegations. The story needs to be about how the applicant's potentially disqualifying situation evolved, what he did about it, how his life has changed since then, why the situation will not adversely affect his ability to safeguard classified information in the future, and other aspects of his life that support a positive whole person assessment. The story should cover the basic interrogatives: who, what, when, where, how much, why, plus who knows, who else knows. Who else knows can be important if there's any concern about susceptibility to blackmail. If an applicant is a veteran, his honorable military service should be mentioned and supported by attaching DD Form 214, a certificate of discharge. It can also help to mention any history of being entrusted with sensitive information, informational security training, and compliance with security procedures. For contractor personnel, there's a one-page document that accompanies an SOR that lets them choose an in-person hearing or a decision by an administrative judge based on the written record. At the bottom of the one-page document, there's a jurat that needs to be signed and notarized. A decision based on the written record is often referred to as a FORM or form response. FORM stands for File of Relevant Material. If this option is chosen, a Doha attorney, known as a department counsel, sends a letter to the applicant with the form attached. It contains the facts of the case, the argument for why the applicant shouldn't receive a clearance, and a copy of the documents the department counsel will submit to the judge. The applicant is invited to submit any additional material he wants the judge to consider and object to any material identified in the department counsel's form. The applicant isn't required to submit any additional information, but if he doesn't submit a written response, the judge will make a decision based only on the information provided by the department counsel. If the applicant chooses to submit a response, he only has 30 days to do it. The form and the applicant's written response, if any, along with any objections to the evidence, are then submitted to the judge, and the judge usually issues a written decision in a couple of months.
Of the applicants whose cases are referred to a DOHA judge for a final decision, about 70% request a hearing and 30% request a decision based on the written record. About 56% of applicants who go to a hearing are denied clearance by a DOHA judge. About 88% of applicants who request a decision based on the written record are denied clearance by a DOHA judge. Despite the difference in denial rate of 56% compared to 88%, requesting a hearing isn't always the best way to go. I'll explain this later. The primary reason applicants who choose a decision based on the written record are far less successful than those who choose a hearing is because they didn't submit a good SOR response, and they don't bother to submit a response to the FORM. At a hearing, the judge and department counsel can ask the applicant questions that might elicit mitigating information the applicant didn't present in the response to the SOR or to the FORM. That's not possible when the judge only considers the written record. Nevertheless, a decision based on the written record can be an effective choice for people who are better at making written presentation than an oral presentation. It also allows applicants to selectively present information without being cross-examined by the department counsel. However, if the applicant chooses a decision based on the written record, the case could still be decided at a hearing if the department counsel requests a hearing. For issues like financial considerations, which are heavily dependent on documentation, an FORM response can be just as effective as a hearing and cost the applicant half as much as a hearing if he hires someone to help him. Applicants who choose a hearing will be contacted by the DOHA department counsel prior to the hearing to coordinate a suitable hearing date. The department counsel will provide the applicant a copy of all documents he intends to submit as evidence to the judge. The documents will be essentially the same as the ones I listed in a previous slide. Although it doesn't happen very often, the department counsel will also identify witnesses he'll have at the hearing. The DOHA judge's assistant then issues a written notice of hearing, which sets the date and location for the hearing. Before the hearing, the applicant must provide the department counsel with the documents the applicant intends to submit and identify any witnesses who will testify for the applicant. The applicant should expect the hearing to be held in a major U.S. city or military base within 150 miles of the applicant's location. DOHA prefers to use courtrooms and similar facilities in federal buildings. Most hearings take about 2 hours. Don't bring a lot of witnesses who will provide the same information. The judge will become irritated and impatient if he hears the same information over and over from different witnesses. If possible, choose a couple of witnesses who know you well and can speak about your honesty and trustworthiness, as well as the security concerns listed in the SOR. You don't want more than 3 witnesses. If there are other people who are willing to testify on your behalf, ask them to write a letter of recommendation for you. You can submit the letters as evidence at the hearing. As I said before, one of the advantages of a hearing for an applicant who represents himself is that the judge and department counsel can question the applicant and elicit mitigating information that wasn't previously presented. In Charlie's case, the judge even offered to keep the hearing record open for 2 weeks and suggested that Charlie obtain letters of recommendation after the hearing and submit them within that 2-week period. The hearing also gives the judge an opportunity to assess the applicant's credibility. This can be very important if the potentially disqualifying conduct occurred recently and the applicant is trying to convince the judge that it won't happen again. Usually, the only people at a hearing will be the applicant, the applicant's witnesses, and the Doha Department Counsel, the Doha Administrative Judge, and the court reporter. Witnesses are normally sequestered outside the hearing room until they provide their testimony. The Department Counsel usually doesn't present witnesses and relies entirely on documentary evidence. With the applicant's permission, others can be present in the room as observers. The one-page document that accompanies an SOR mentions video teleconference, or VTC hearings. These are done primarily for the convenience of the government when the applicant is at a very remote location. Sometimes they're offered to an applicant at a remote location to reduce the wait time to schedule a hearing that would otherwise be done in person somewhere close to the applicant. If an applicant lives within 150 miles of where Doha regularly holds hearings, a VTC hearing will not be an option. Even when Doha offers a VTC hearing, the applicant can request an in-person hearing if they are willing to travel to a location where Doha regularly holds hearings. The location of the hearing or the VTC facility is an important consideration if the applicant wants to present witnesses to testify on his behalf. Whether the hearing is conducted in person or by VTC, the judge normally doesn't announce a decision at the conclusion of the hearing. The judge waits to receive the hearing transcript, which takes about 2 weeks, and issues a written decision a month or two later. A copy of the written decision is sent to the applicant, and the applicant's eligibility is concurrently posted to JPass or DISS. An applicant doesn't have to provide a detailed response to his SOR. He can simply answer each allegation with "I deny" or "I admit," and not offer any mitigation or explanation. I call this an abbreviated response. He can then concentrate on making the best possible presentation of his case at a hearing or in response to the FORM. This could be the best way to go if the applicant needs more time to mitigate issues and obtain documentation. If there's any possibility of having the SOR withdrawn based on the written response to the SOR, and if there's sufficient time, I usually recommend a client do the best possible job answering the SOR. That way, the applicant might get his clearance without having to go through the hearing or respond to an FORM. This happens to about 24% of applicants who submit a written SOR response. With my cases, it happens more than 50% of the time. Even if the SOR isn't withdrawn, all of the heavy lifting will have been done in the SOR response, and the applicant will only need to reiterate some of the information already provided in the SOR response and provide updated information to the judge at the hearing or in the FORM response. When an applicant has delinquent financial accounts that he hasn't begun repaying, I usually recommend that he ask for as much extra time as possible to answer the SOR. I also recommend that he do an abbreviated SOR response to keep his case alive. If he requests a copy of his investigative file from NBIB, it's doubtful he'll get it in less than 30 days, and as I previously said, Executive Order 12968 says the SOR should not be due until after he receives the investigative file. So there will always be justification for an extension to the due date for the SOR response. Once he submits his SOR response, he'll have about 2 to 3 more months to resolve his financial delinquencies before he'll have to make a detailed presentation to a Doha judge. When I say resolved, I mean either pay off or start making installment payments on the debt in a manner acceptable to the creditor. Obviously, the more payments he makes before presenting everything to a judge, the better his chance of getting a clearance. Because of this, delays can work in your employee's favor, especially when financial issues are involved. I was contacted by a woman who received an SOR at the end of October 2019. There were 17 delinquent debts listed on her SOR. She had repaid several debts, but there were still a few small debts and 4 large debts she hadn't paid. She was uncertain about what she should do and how she should answer the SOR. I recommended she get an extension to the suspense date and then do a simple I admit or I deny response to each of the allegations on the SOR. She did that by herself and submitted it in December of 2019. DOD-CAF didn't like the wording of her SOR response, so they sent it back to her 2 months later and gave her 10 days to correct and resubmit it. She resubmitted her response in early March 2020. Her second SOR response must have been misplaced at DOD-CAF because by late August 2020, she hadn't been contacted by Doha. I had her ask her FSO to inquire about it, and that got it transferred from DOD-CAF to Doha. In October 2020, she received an FORM. I had urged her to pay off the remaining small debts during the last 2 months of 2019 and contact the other creditors to arrange repayment plans. She started making installment payments on the large debts in January of 2020. By the time her FORM response was due, she was able to submit documentation showing she had paid off all of her delinquent debts, including the large ones. This case is currently being reviewed by Doha. I'm pretty confident that there'll be a favorable decision before the end of the year. In another financial case, my client and I did the best possible job we could in answering the SOR and requested a hearing. That was in December. In February, the department counsel contacted me to schedule the hearing. I gave her the information she wanted about our availability for the hearing. I also sent her evidence of 3 additional payments my client had made on each of his delinquent debts since submitting his SOR response. I asked the department counsel to consider withdrawing the SOR based on these additional payments. 4 months went by without a reply from the department counsel. So I recontacted her and provided her evidence of 4 more payments. I also highlighted other aspects of the case that made it ripe for withdrawing the SOR. A week and a half later, she sent me an email that the SOR had been withdrawn and my client was granted a security clearance. The main difference in these 2 cases is that the woman in the first case concentrated her effort on the response to the FORM rather than the response to the SOR. This saved her the expense of professional help in answering her SOR, which would have been unsuccessful anyway, and gave her more time to fully resolve her financial delinquencies before providing a solid response to her FORM. The man in the second case successfully focused all of his effort on the response to the SOR because he had a reasonable chance of having the SOR withdrawn. In both of these cases, the applicants began resolving their delinquent debts before they received their SORs, and did as much as they could as quickly as possible.
Either the applicant or the department counsel can appeal a judge's decision. About 20 to 30% of Doha judges' decisions are appealed. The appeal is submitted in writing. There's no personal appearance before the Doha Appeal Board. The board is comprised of 3 Doha judges. In an appeal, the Doha Appeal Board doesn't take a fresh look at the case and arrive at its own decision. The board only reviews the material issues raised by either party to determine whether there were factual, procedural, or legal errors. The appealing party must raise a claim of a specific error and identify how the judge committed the error. No new evidence can be considered. In most appeals, the appellant claims that the judge's conclusions were arbitrary and capricious because they were not supported by the evidence or because the judge ignored or gave too little weight to certain evidence. There are 3 possible outcomes to an appeal, and 2 of them are bad. The appeal board's decision can be to affirm, reverse, or remand the hearing judge's decision. Most remanded cases merely get rewritten by the same judge in the manner that satisfies the appeal board without changing the outcome. As I said before, only 1 to 3% of applicant appeals are successful. This has all been about cases involving contractor personnel whose cases are decided by Doha. Much of the information is applicable to federal civilian and military personnel, but the process for them is slightly different. In this presentation, I've used a number of anecdotes involving Guideline F, financial considerations, because Guideline F is the most frequently cited issue in SORs. Since 2008, financial consideration has appeared in about 50% of SORs. Guideline E, personal conduct, has consistently been number 2, and Guideline B, foreign influence, has been number 3. Since June 2017, foreign preference has dropped from number 4 to about number 7. The guidelines for drug involvement, criminal conduct, and alcohol consumption have changed positions relative to each other from year to year. It's important to remember that a security clearance adjudication is an attempt to predict future conduct based on past conduct and conditions. It's not a judgment on things people have done or that have happened to them. And it doesn't matter how good a person the applicant is. What matters are the mitigating factors and that the applicant can prove or at least support with the evidence he submits. This is important and is worth repeating. What matters are the mitigating factors the applicant can prove and at least support with the evidence he submits. All of this takes time. When dealing with the government, you can count on things taking longer than you expect. Here's a typical timeline for events following the issuance of an SOR if nothing goes wrong. You can see that it takes about 7 months from the time an applicant receives an SOR to the time the Doha judge issues a written decision. This assumes that everyone does their job properly. I recently had an SOR response stuck at the DoD CAF for 5 months, and all they had to do was forward it to Doha. This shouldn't happen in the future because pretty soon Doha will be issuing SORs and responses will be submitted directly to Doha. I believe that DoD CAF will continue to write the SORs. DoD CAF will then send the SORs to Doha for legal review as they previously did, but rather than returning the approved SOR to DoD CAF, Doha will send the SOR directly to the applicant. If an applicant is denied a clearance, he's barred from reapplying for a clearance for 12 months from the date of the Doha judge's decision. The main obstacle to reapply for a clearance is getting clearance sponsorship. Also, the process for reapplying is different than a regular clearance application. After an applicant who was previously denied a clearance submits an SF-86, it's necessary to obtain approval from the director of Doha before a clearance investigation can be initiated. So, It's important to keep a copy of everything related to the clearance denial: the SOR, the SOR response, the judge's written decision, and if there was a hearing, a copy of the hearing transcript. All of this will be valuable when submitting a request to the Director of DOHA justifying why the person should be allowed to reapply.
In this last slide, we've provided links to articles about SORs, FORMs, and hearings, as well as some other useful reference materials. There's a link listed here to an article about letters of recommendation for security clearance. These letters can be submitted as attachments in response to an SOR, an interrogatory, or an FORM. They can also be submitted at a hearing. I've seen hundreds of recommendation letters, and most of them are woefully inadequate. Very few actually make a recommendation like, "I recommend John Smith for a security clearance." Most don't describe the nature, period, and frequency of contact the writer has had with the applicant, so the adjudicator has no idea how well they know each other. I believe that letters of recommendation are very important, especially since reference interviews in a background investigation report are not admitted as evidence. The DOHA judge in Charlie's case felt they were important enough to make a point of suggesting to Charlie that he submit a few. You should have your employees read the article on letters of recommendation. It'll help improve their chance of successfully answering an SOR. One last thing about self-representation compared to professional representation. Earlier, I said that 80% of people who receive an SOR represent themselves, and a large majority of them are denied clearance. The 20% of applicants who hire an attorney or personal representative have some of the most difficult cases. Nevertheless, the majority of them receive a clearance. Although there are no statistics on it, anecdotal information suggests that a large majority of people charged with drunk driving hire a lawyer. The average range of cost for legal representation in a first offense drunk driving charge is $1,500 to $4,000. Not much different than the cost to have an SOR response prepared by a professional. But there's a big difference in outcomes. In about 80% of drunk driving cases, people receive some punishment for their offense. This usually totals to about $4,000 in fines, fees, and other costs, as well as temporary loss of driving privileges. In the worst cases, it might also result in some community service or a little jail time, but it rarely results in loss of employment. When a security clearance applicant is denied clearance, it usually results in losing or being denied a job, as well as a period of unemployment. This can be a career-altering event. Considering that people with security clearances earn thousands of dollars more annually than uncleared people, the monetary losses over time are far, far greater than the cost of a drunk driving charge and can severely limit future job opportunities. So why are people so much more willing to pay for professional help to deal with a drunk driving charge than they are to pay for help to deal with an SOR? That concludes our presentation. Thank you for your time and attention. If you have any questions, please visit our website at www.fedcast.com. That's www.fedcas.com. There are numerous informative articles posted there, as well as detailed explanations of the services we offer.